Hello, I'm Ron Graber. This is BL260, Principles of Business Law, here in the fall of 2020. And I'm glad to be able to teach you, even though I'm not in person. I prefer teaching in person. Maybe you prefer being here in person. But unfortunately, it's just not possible at this time. I told my chairman that I would teach in class if necessary, and I had no problem with that. But probably it's best for all of us this way. So what is this Principles of Business Law course, and who am I? I'm Ronald Graber, like I said. I've got a JD and an MBA. I've been a professor of law, adjunct professor of law at Chase College of Law for a while, and I've also been here for since 1981 as a professor of business law. And and the course, what are the objectives of the course? Students will learn certain things in this course, hopefully. They'll learn basic rules, principles, and other considerations of law on how the law gets decided. They'll learn how disputed cases are handled. All cases are disputed, right? Otherwise they wouldn't be in court. So you have a case going to court when the parties can't agree on how to settle their differences. Unfortunately, that happens way too often in our society. And on the other hand, it's good for me as a lawyer. It provides me with business, but I don't really need the business nowadays because I teach, which I prefer anyway. Okay, so how disputed cases are handled by our legal system. And the nature of our constitutional legal system, I'm going to talk about that. We're going to talk about the importance of private contracts in promoting prosperity. I mean, originally the law has been thought of as having a private part and a public part. The public law largely deals with government and its interactions with large corporations or businesses and taxes and that kind of thing. On the other hand, there's a lot of things that happen privately between individuals. So people enter into contracts, people sue one another, people have to go to work for one another, and there's always the question when you're interacting in society, maybe with the government, as to what your civil liberties are. So we're going to be talking about all those things. So the nature of our constitutional legal system, the importance of private contracts in promoting prosperity, because you have to have incentives, and this is the way that both parties get incentivized by a private contract. The nature of ethics. So our law has values, and these values are largely derived from our ethical beliefs, and these change over time, no doubt about that. Our understanding of things change over time, and so there's been lots of changes in our society, I think, because society is changing, because we're learning more and more about things all the time, and we'll try to keep up with those kinds of changes and talk about those things. So when our Constitution was written, not a word was mentioned about privacy. Yes, there was a clause in it protecting your privacy in the house, but it didn't mention the word privacy. It just said that they had to have a search warrant if they wanted to come into your house. It said that if they want to quarter troops, which the British used to do to their citizens, they can't do that without paying you, of course, or they can't command you to allow them to do that. So we have these protections, civil liberties, not least of which is the right to speak our mind freely. And this is always going to be contentious, as some people will say, well, some speech is treasonous, some speech is disruptive. And indeed, our system is very open in terms of speech. We allow people to speak so long as there's no likelihood of immediate harm. There has to be a clear and present danger, was the old phrase which sticks in the mind. It's really not the test we use today, but we have a test that's somewhat similar to that. Anyway, necessity of ethics, and so tort law and criminal law, the common law, were largely based on that. What's tort law? Tort law is the law of wrongs. If you're going to sue somebody for bashing into your car, or walking up to you and punching you in the mouth, if you're going to sue somebody for that, that's a matter of tort law. He wronged you, and you can sue him and collect for whatever harm he did, And if it was malicious, like punching you in the mouth, you can actually collect punitive damages from him if he did something that was outrageous like that. And the jury used to be totally free to give any amount of damages for that, and they oftentimes measured the damage by how wealthy the individual was who did it, because the idea was to deter him from doing that in the future. Nowadays, the Supreme Court has decided that punitive damages have to be proportional to the physical harm caused. And so there is a limit to how much punitive damages you can get. And the punitive damages did serve a purpose. I mean, something like somebody walked up to you and punched you in the mouth. You may have had some physical injuries, and it may seem like a lot of money, maybe a couple $1,000s, you know, with medical costs and treatments and whatever. But, you know, that's nothing when you talk about lawsuits, what you'd have to pay an attorney to maybe take a case like that. So even on the basis of the lawyer just taking a proportion of the money that you win, it's probably not worth it for that. So punitive damages, on the other hand, would allow the jury to award a substantially larger sum, most of which could then be going, a lot of which would maybe be going to have an attorney. So an attorney is going to be incentivized maybe to bring a case in court like that in order to give you some substantial damages. And the idea was to deter somebody from doing something like that. So a rich individual with a lot of money might do outrageous things and get away with it in our society as it is now. Anyway, we'll also talk about the efficiency of laws and other regulations for effective and efficient administration of a democratic government. Do we have a democratic government? Some people nowadays question that, in that, you know, with the Supreme Court deciding that corporations can create all this money and donate all this money into putting them into funds to help elect people they want, and restricting the way we had been actually trying to make our elections more about people's votes and less about how much money they can raise and therefore sort of buy the election. Those things are changing. So do we have a democratic government? I'm not going to go into that in too much detail. That's more for political science, I suppose. But it's obviously an important point, because when we get into it, judges are oftentimes asked to maybe find a statute to be unconstitutional. When they find it unconstitutional, obviously if it is unconstitutional, they ought to call it that. But a lot of people will say sometimes that, oh, they're misusing it and just putting in their own political purposes. And so oftentimes you have that kind of thing. Now, right now we have this, we've had this case, you know, Shelby County case, which is largely disputed as being a return to the era where southern states can basically restrict the rights of black voters, which is kind of interesting to look at. So it's interesting to see how the law has been changing. So we'll keep things up to date and talk about current things in this class, because I think you'll find these things interesting to what's happening now as opposed to what happened in the past. And we'll also talk about things in the past, because history has a lot of lessons for us, and a lot of them actually arise out of cases. So we're not studying history here, but we're studying the law, and the law has been largely evolved by the history of the country. How will your learning be measured? Well, we want the learning to be measured by a fair, relevant, and objective way. We want to have tests that actually are drawn from what we have talked about in this class, what we have, what you've read, what you've seen in the PowerPoints. We want you to become familiar with these, and we want it to be objective and not to be some subjective matter. You know, and so test and relevant to business law, and that's what we're going to do. So quizzes also. I'm going to be showing you PowerPoints when I talk. So I'll usually be up in the little corner of the screen talking, and my PowerPoint will be off to the side, so you'll be able to follow along with that. So as I'm talking, you can look and see what the words are that I'm saying, in case you have any difficulty. But also it helps you to remember them, to see them as well as to hear them. So the more inputs you can get, the better. The more repetition you can get, the better in terms of remembering things. And we want you to remember these things long term. That's why we do have lots of repetition of things, actually. The reason that in school you sometimes find repetition of things is not because the professor wants to be boring, and hopefully he's not being boring by being repetitious as to some degree. We're not going to do things by rote, certainly. We're also going to try to explain things so that you understand the meaning of these things. Why did the court find the way it did in Shelby County? That has a lot to do with the history of this country, and a lot of it has been overlooked. Anyway, so we'll talk to some degree about the meaning of these things. We'll talk about the values that are important. So these PowerPoints are there to help you understand the material. You see it, you hear me say them, and you should maybe review them on your own, but also to give you another experience with some of the questions. I will actually give you quizzes based upon those PowerPoints. So each time we see a lecture, there will be a quiz at the end, and you'll have to, fill that out, and we'll keep track of that and see how you're doing. That's in order to encourage you to do it. And I urge you, you can watch these things anytime that's convenient to you. We understand that there are some difficulties. Some people are sharing a computer, and there are other reasons why people have a difficult time scheduling it. So there's not going to be any strict schedule as to when you have to see these quizzes or these PowerPoints. And there will be, however, an expectation that you'll get the quiz in usually at the end of the week. So you'll maybe have Monday to send that in, the quizzes. And the quiz will be relatively short and be drawn directly from the quizzes, and it's simply a matter, if you don't know the answer, you can go and look at the PowerPoint again. Look at the class, the video presentation again. So you'll be able to do well on these quizzes, and that gives me confidence that you are making an attempt to do it, and I can therefore work with you in terms of how you're doing. And people will do differently. Some people will do better than others, and that will be the case. But hopefully everybody will be able to do well enough to certainly pass the course, and many people will be able to get a decent grade. And but you need to do the work, and you need to work at it consistently and over time, because the long-term memories are created over time. They're not created by one exposure to an ideal. You've got to kind of like have more than one. So there'll be a lot of talking about different ideals, and I'll bring up ideals that I think are important more than once. So when I was taking notes as a student, I always knew that if the professor started saying something more than once, it was important. I'd always write that stuff down, and that was very important. And I had a friend who had actually done that in her book, and I took the class after she took it, and she did a very good job of marking up the book. Because as the professor was lecturing, I noticed that the key points seemed to be highlighted in the book. And so when I studied for the exam, I just read her underlinings that she had in the book. And I wound up getting the highest grade in that class. And I found out that she had the highest grade. So, yes, but I was learning it all along, so I always felt good about property law. Anyway, so there are quizzes, and they will count for your scores, so you'll want to do them. Then there's homework also, to do. Maybe I'll have you doing some TED Talks, and again, there'll be some questions you have to answer, much like you did with me in terms of doing that. So I like to give people either some article or something to read, or maybe something on the internet that they can watch, and then answer questions so that they have to pay attention to what's being said in the film. If they do it right, they will learn the material and do well. And I will give test question over some homework questions too. I'll give, so some of these homework questions might wind up on the test, as will the quiz questions that are coming from the quiz. And then there will be totally new questions you haven't seen also. Also, I hope to have you do at least one project, maybe a couple projects. And you'll do these as a group, and maybe present a group paper. I don't know whether you'll actually be able to actually present it, for everybody to see, or whether or not we'll just simply look at it. I think I'd like to have everybody, seeing your group presentation, because you can take pride in doing it. And we'll have you do these group and working in the groups. So we'll try to form groups. Hopefully we can do that. So grades, your grade, 20% of your grade is going to be on each of the first 3 tests. So you'll have 20% on test 1 over contracts, 20% over test 2, which is on tort liability and criminal law, 20% on test 3, which is law and the regulatory state. The final and the 4th test is only worth 10%. And, it's going to be over ethics and public policy issues. And so some of those constitutional issues may show up on that test question. Then the rest of the points are from your quizzes and homework assignments and the project that we will have at least one of those. Like I said, we'll probably have maybe some Zoom contact to work on that. We can, if you have questions, we can always schedule some sort of a Zoom meeting with you, or a meeting, some other kind of thing. Probably not going to be able to meet in person. I'd like to meet in person, but I don't know if they'll permit us. My thinking is they probably won't at this point encourage us to do that. Certainly they'll probably discourage us. Contracts topics covered. Okay, so these are all going to be bases. Each of these will probably be maybe part of a PowerPoint presentation or an entire PowerPoint presentation. So we'll probably have a PowerPoint presentation on the nature of contracts. Contracts is important to understand in terms of business law, obviously. This is something that every businessman should understand, the nature of contracts and the things you need to do in a contract. Offer and acceptance, we'll have that. Consideration. You can see over to on the slide here, you can see the chapters on the other side. So there's a chapter for each of these. So the book has lots of chapters on contracts, and but we'll go over in class 2. And so consideration, offer, acceptance, and consideration is something that you need to understand. So basically, a contract first comes into existence by a certain process. That process is offer and acceptance and consideration. Without an offer and acceptance and consideration, you do not have a contract. There are other elements to a contract which are basically disqualify a contract from being enforceable. We'll talk about those also. Capacity, legality, and fraud. Also, mistake. So a mistake of fact can invalidate a contract. We'll also talk about warranty. Maybe not as important a law, because the consumer protection laws have been greatly weakened over the years, starting back in the 80s, where, for that matter, antitrust and a lot of laws that were meant to basically empower little people like yourself, not that you're physically little or powerless, but ordinary people, giving them some sort of leverage in the game. So I was able to use warranty in one of my cases. I was able to use consumer protection laws in one of my cases to actually get my client a fair deal. And we'll talk maybe about that case later. Performance of contract is another thing that we'll talk about. So, you make the contract, that's the offer, acceptance, consideration, and then you perform it. If you're going to have it in writing, it's important. Some contracts are required to be in writing. Not all contracts are required to be in writing, but the statute of frauds lists contracts that are required to be in writing. So we'll cover those 6 kinds of contracts that have traditionally been required to be in writing. There are other statutes that require even other kinds of contracts to be in writing. And contracts are, if they're important, are typically going to be in writing anyway. Then there's the parole evidence rule. Parole evidence rule doesn't require a writing, but it applies to writings. So if you have a written contract, you can use the parole evidence rule. And basically what it says is that whatever the parties have written down and agreed to and signed, that's their contract, and that cannot be altered in any way except and under extraordinary circumstances. And there are exceptions to the parole evidence rule, and usually these are extraordinary kinds of things. And so we'll talk about the exceptions as well as the rule. Statute of fraud. So statute of frauds is requiring writing. Parole evidence rule simply applies to a contract and limits the parties to terms that are present in the written contract. Third-party contracts. These are contracts, for instance, if Junior wants to buy a car, he gets Mom or Dad to co-sign for him. It's a third-party contract. It's also a third-party beneficiary contract. So, so we'll talk about those kinds of contracts a little bit. Consumer protection. We'll talk about that. Breach and remedies. So you have formed the contract. That's offer, acceptance, consideration. You have performed the contract according to the rules, according to the contract, its terms. And if you haven't performed it right, it's a breach. You have to do what you promised to do. The other side has to promise to fulfill their promises. Each side has a right to expect the benefit of their bargain. And if they don't get the benefit of the bargain, that's the job of the court to give them that. That's what remedies are about. So that's contracts. Now, contracts is one of the major topics we cover. Another one is the ethical systems, torts, and crime. So we have cases that are based upon torts and crime. Mostly it's going to be about torts. We're going to cover, however, the bases, the values that underlie it, which are largely ethical values. So we'll talk about the duty ethics, we'll talk about utilitarian ethics, we'll talk about rights ethics, we'll talk about virtue ethics, and we'll talk about their implications. Wrongs and intentional torts. Basically, some torts are intentional, like punching you in the mouth. That's going to be a tort if that was done intentionally. If a guy's just careless and he hits you in the mouth, it might be negligence. You might still get damages, but it's different implications, because an intentional tort oftentimes would enable you to maybe get some punitive damages, whereas negligence, it has to be gross negligence to get punitive damages. You can get punitive damages with gross negligence, but not otherwise. You have ordinary negligence. If a person's just being careless, that's all you can get. But if he gets drunk, he gets behind the wheel of a car and speeds, that's gross. So you get more damages that way. Affirmative defenses to negligence. So we'll talk about that. So we have comparative negligence, and we'll talk quite a bit about comparative negligence. So we'll talk about how negligence arose, what it was originally, and how it changed, and what it is now. And it's different from state to state, so we'll talk about how it's different from state to state and what these differences mean in terms of your rights. And there are some affirmative defenses to negligence. If somebody's being negligent, he can affirm that you were to some degree responsible yourself, that you have actually to some degree been careless yourself, so you were negligent for your own safety, or you intentionally assumed a risk you knew to be dangerous and it was an unreasonable risk, or maybe it was a reasonable risk, but it's something that the law will allow you to use to deny him some recovery. Nowadays, negligence, we have comparative negligence, which means that for the most part, in most states, we compare both sides' negligence, and you just simply pay for the greater amount of negligence of the other party. But if you're equal, then the party would have to pay you equally. However, in some states like Indiana, if you are, say, 51% at fault, you cannot get a recovery at all from the other side. He doesn't have to pay that 49%. And you say, well, that's not a whole lot of difference. And isn't the judgment of whether it's 49% or 51% simply a subjective judgment made by the jury? Yes. Is it affected by how they view the jury? In other words, could they let a person who seems to them to be a nice person because they like the way the person looks, or they like their name, or whatever, they like that they're well dressed or something, does that make a difference? Yes, it does make a difference. And so we have these factors, and yet we basically, in states like Indiana, will deny people recovery at the 50% level. Sometimes, like in Ohio, at 50%. If you're 50% responsible for the injury that was done to you, you can't collect 50% for the other side. He gets a pass in Ohio, so that's different. Most states are not that way. Most states are pure comparative negligence. However, Midwestern states and in southern states, the so-called Bible Belt, tends to be different. Anyway, affirmative defenses to negligence. So we'll talk about those, and we'll talk about comparative negligence after we talk about those. Strict liability, which is liability without fault, and abnormally dangerous activity in animals. We'll talk about that. If you have a pet dog, are you going to be liable if he bites somebody? We used to say every dog had one bite. It's not truly true. The question is, do you have knowledge that your dog is likely to bite people or not? If you have knowledge that he's dangerous, then you can become strictly liable. So has he attacked people? Maybe he hasn't bitten anybody yet, but he's been attacking people. He knows he's running after people, and you got to do something about it. And it doesn't matter what you do about it. If somebody gets bitten or attacked by your dog, basically strict liability means you're liable without fault. Therefore, there's no guarantee that any precaution you take can actually guarantee that you won't be held liable. And so we'll talk about that. Product liability. And product liability basically is holding manufacturers liable when they produce a defective product that caused harm to an individual. And we'll talk about that. So there's various kinds of things. The product usually has to be defective. However, sometimes the product is not maybe defective, but it's being used in the wrong way, and therefore how a manufacturer sells this product becomes an issue. Is he encouraging people to use it in a way that's inappropriate, which would ordinarily maybe be a defense he could assert if they didn't use it in the way it should be used. But if he's showing it being used in a dangerous way, and people go out and use it that way, then that advertisement can be used to hold him liable for these people, oftentimes maybe young people. And we'll talk about two interesting cases involving Jeeps and trucks being driven through a wooded area in a dangerous way at high speeds and turning very quickly. And kids would go out and do the things they saw on the TV commercial, and they would wind up breaking their necks and killing themselves and all kinds of injuries from that. So that was rather silly for the manufacturer to be showing a truck being used in a dangerous way. Strict liability, liability without fault. The circus is held liable if the lion escapes. If you've got a pool, if people can get into your pool and they get into your pool, you're liable because you're strictly liable in many cases. It's thought to be an attractive nuisance for kids who maybe sneak into your pool and drown when nobody's around. So these things, we'll talk about them. And we'll also talk about the defenses to strict liability, because there are some defenses. We'll also talk about crimes. We're not going to spend a whole lot of time on crimes, but we'll talk a little bit about crimes because we had things like the Enron case. So that's a major test worth 20%, these kinds of issues. Law and regulatory state, and so the administrative state, sometimes people call it. The first topic I'm going to start off with is probably nuisance. So I have a little talk about nuisance, but it's part really of my environmental PowerPoint. However, the book does have on page G-19 a definition of nuisance, and says that it's basically whenever you interfere with somebody's enjoyment of his property unreasonably. That's basically it. It's a little longer than that, but I don't have too much time to give you all the details now. We'll go over it later. Environmental law, I think, is an important kind of thing, being talked about a lot, and so we'll talk about the environmental law, not just simply all aspects of it, not simply just the global warming, which we'll talk a little bit about. Employment at will, we'll talk about that. People don't understand the terms of their employment. A lot of people think they go to work and they got a contract of employment. Typically, you're not having a contract of employment. You're an employee at will and can be fired for any reason, and it doesn't have to be a good reason. However, most employers are reasonable and will not fire good employees doing a good job. But sometimes there might be some personal grudge, something that shouldn't be done to somebody, or maybe some bias or prejudice. However, we do have some relief for that, in that we got employment law, which deals with some of the recognized discriminations that we prohibit. Not all discriminations are prohibited, but we've over the years had a number of statutes, and we'll go over these different statutes that cover discriminatory law or anti-discrimination laws. and how people are protected by them. And of course, you still have to make your case. You have to prove your case. You have to prove that you are being discriminated against. So it's not a hands-down kind of thing, although there is a presumption created when you assert that the employer would have to, in a case where he fired somebody that looks unreasonable, it may appear to be discriminatory if it's one of these persons that's qualified for protection against discrimination. Other statutes prohibiting discrimination, other employment statutes, there are other employment statutes I hope to cover. But employment is a very important part of your life, right? So constitutional law, actually, that's another part of the law that we'll cover. Protection of your civil liberties, and you see each of these things I've got like the chapters that are that. Now some things are, you know, constitutional and civil liberties are going to be in the same thing, and also that particular chapter I don't think is maybe going to be adequate. So I'm going to maybe talk about things that are beyond that. So I remember once saying, well, you can read the book or you come to class and either one you can pass the test. You should be able to pass the test with either one. People would ask me that question, and I shouldn't have been telling them that they could do it that way. And what I found was that people were not coming to class. A lot of people were not coming to class, and these people were not doing well on the test. The students who come to class were doing better. Now, possibly some of that might be that students who were coming to class were also maybe reading, some were at least reading the book. But I also think that it's powerful to hear somebody else. I mean, it's much more memorable, I think, to hear somebody talking about something than it is to look at how it's talked about in a book. And so that's really it. Now, there is a test on ethics, and we're going to be covering the three systems of ethics, four systems of ethics. You know, utilitarianism and virtue ethics and duty ethics and rights ethics. We're going to talk about those, and we'll also talk about other policy values on that test. So we'll also have, that'll be sort of ethics and constitutional law, and we'll talk about that. And there are chapters for these kind of things, and we'll be giving you those in a syllabus that we will have for you. And you should be having that soon if you haven't gotten it already. Like I said, we'll have some sort of Zoom meeting, and so I'll give you information, invite you to a Zoom meeting or some kind of meeting, WebEx or maybe some other platform where we can go over things, and you'll be able to talk to me, and I'll be able to talk with you, and we'll be able to see each other and have a live experience. And I want to thank you each for signing up for the class, and I hope you will continue to work on these things. So every week on Monday there'll be a presentation that you can look at, and in the presentation there will be a PowerPoint slide, and those PowerPoint slides will be available for you to separately download. So you don't necessarily have to always look at the presentation to get the slides. You can actually look at the slides and download them too. Print them out if you want to, if you feel more comfortable reading things. Maybe for eye reasons, and so I want you to keep up with it and do those quizzes shortly after viewing it, and that will actually serve as some sort of reinforcement of what you learned when you were going through it. So you'll hear it, you'll see it, you'll review it, and hopefully if we can, we'll maybe do some sort of review at the end. Maybe have a review lecture with a PowerPoint on that, and so we'll do this thing, and hopefully everybody will do well in this class. I want you all to be top students. I have no problem with you getting good grades. I believe I've been criticized in the past by some faculty for being too easy on my grades. I don't think I'm that easy on my grade. I think the students earn it, so they have to do the work, I think. So you know, if we were having a classes, I'd require you to be there in class every day. As it is, I'm going to require you to do the work steadily, and I expect to be getting those test results every Monday after you've seen the videos and those quiz results. So I said test. in my mind, there's not much difference between a quiz and a test, except the quiz is usually shorter and over a smaller amount of material, and a test is usually more material over something on a longer test. The project, I already have in mind to cover a contract, a notorious contract that is the sharecropping contract, and we'll see why that contract was a bad contract, what was wrong with that contract, why, in my opinion, our justice system failed in not ruling that these sharecropping contracts were oppressive and not doing more for the people who were sharecroppers, both black and white people were sharecroppers. Mostly it was blacks, certainly, because blacks basically came out of Civil War without any property. They had hoped to receive some property in the hopes that there would be a redistribution of lands that would be taken from maybe rebel leaders and maybe distributed, but that didn't happen. In fact, it was largely a matter of the South being turned over to, if not the same leaders, but leaders who were the next generation, maybe of those same peoples being actually installed in the leadership position. So Reconstruction in the 19th century was kind of a failure and was mischaracterized. When I was going through school, they had the Dunning School of Thought, which portrayed the Reconstruction as being a terrible thing because scallywags and carpetbaggers had ripped everybody off. And that was largely, we would call it nowadays, misinformation. It was bad news, it was false news, it was exaggerated. Yeah, there was some corruption, no doubt. There was corruption in the North too, and things that didn't involve race at all. Look at Tammany Hall. You know, it was a terrible kind of thing. So, and you know, the black people who had some representation and were representing those people were certainly no worse than their counterparts, and maybe actually, in fact, were much more honorable. So I'm going to actually go through that because it's relevant today. Nowadays we have also terrible contracts, oftentimes in financial terms. Also, do you realize that for the past 40 years, most working people have not gotten a raise? Although there's been lots of inflation, our wages have stayed stagnant, and so one had to manage himself very well. And if you didn't have a job where you could put away a certain amount into a pension fund, if you didn't have a pension plan with your employer, you're probably not going to be able to actually put away enough money to take care of yourself in old age. And we're stuck with the Social Security, the little bit that the government begrudgingly gives you. And you see that the government oftentimes is being run by people who are very reluctant to give ordinary people some sort of payment. You see that, you know, they're very generous. Some people say we have corporate welfare. Well, maybe it's wealth welfare. You know, we take care of the wealthy. We've had lots of tax cuts in which it was very lopsided. And, you know, so some people think that the reason that the wealthy take so much of a percentage, top 1% take a large percentage of the wealth, people think that it was because these people are better educated and have more skills. For the most part, that's not true at all. A lot of middle class people who have very good skills and a lot of education and a lot of talent are not able to make nearly as much money as these people who were born with wealth and think that somehow they're entitled to it and that is somehow a mark of their superiority over the rest of us, which gets to be a little bit boring after a while once you realize what's going on. Anyway, that's the thing, and the project will be graded, and you'll be working on it as a group, but I hope to also allow you in to share with me your thoughts about what the members of the group were doing in a confidential way, so nobody has to come out and, you know, publicly accuse anybody, but each side will be able to present their point of view. My argument is that probably you should work very hard to do that, and hopefully we'll be able to get you all into a good group that's congenial. Maybe if we can, maybe you'll be able to choose your group members as opposed to me assigning people to a group. That way there's some, but you wind up sometimes with people who don't know anybody, and those people just have to be assigned, and you're kind of stuck with whatever they get then. You know, but a lot of you maybe have had classes with a lot of other people because this is not your first year, and so you know probably somebody in the class, and maybe you can team up with them. So thank you very much. Send me emails if you have any questions, or if you want to have a Zoom meeting with me sometime, send me some email, and so we'll try to set it up. Thank you. This is the book. It's recommended that you read it before you take a class. You know, read the relevant chapter ahead of time. You'll be able to take better notes. However, I'm going to be testing not primarily from the book, but from the lectures. So you'll want to definitely take notes on the lectures and study that more hardly. There's a lot of things I can't talk about in the book because the book is crammed full of information. It's quite packed. And so there's a lot of material in there. Read it as quick as you can, and you know, try to get some reinforcement from that. And some of you will maybe want to study it a little harder. But it's the 4th edition of West Business Law. It's in the bookstore. You don't have to, you could buy a packet that's got something like that too, and it also has some material. You don't necessarily need to get that packet with that internet program that West Business Law offers, because I never have made assignments from that. Those are good programs, and if you want to certainly get that, you certainly can. Let me know if you need any help in that regard. But I'm not going to assign it. I have my other homework that I assign, which, you know, is more tailored to my course. And I have also usually made available a supplement that people can get in the bookstore also. So I'll make that available again. It's getting a little old, but it does cover a lot of the same things when I talk about things like labor law. A lot of that's actually there. And so, you know, that's just another resource for some people. So thank you very much.